demands of you to come and save the soul of this Constitution. In conclusion, what history will record after these proceedings today? My lords and my lady, let me close by saying this. The impeachment of Honorable Gachagua will be recorded in the constitutional history of this republic. The question is, what record will say? If this court allows to stand the impeachment, the record will say that in Kenya, a deputy president may be removed from office on the basis of political metaphor without any finding by a competent authority and without meeting constitutional threshold and through processes that selectively targets political opponents while exempting those in power from equivalent treatment, scrutiny. If this court grants the relief sought in our petition, the record will say something entirely different. It will say that in Kenya, the Constitution means what it says, that the threshold of impeachment is real and it is high, that the rule of law is not a slogan but a shield, available to every Kenyan, including a Maasai like me, including those whose politics are inconvenient to the powerful. We urge this court to make the right record. We pray for orders as prayed in our amended petition, including a declaration that the impeachment of the first petitioner was unconstitutional and an order that he be compensated as prayed. So I submit, my lords. Thank you. And always, my lord, whenever I speak and address this court, my learned colleague is my friend, he always interrupts my presentation.
There was a petition in this matter, especially during the proceedings.
Yes, my lord.
No, I'm suggesting you. There was a petition in this matter, Senate Council, I've not seen this in this second arm of proceedings. This council level.
I have you see. I think he came during the first big conduct.
Yes, I have not seen him again, so I have no information. I think he was appearing in his pastoral capacity, yes, and also for one of the civil societies. K2. Yeah.
Well, my lord, now that issue arises, he's one of the senior lawyers. I've had the privilege of calling me to tell me one or two things that have clarified some of the points we've been trying to make. He's okay. I don't say much, but he's okay. Yes. Now, my lords, I'm happy for the time given to my learned colleagues, Mr. Martin Kamwaro, to deal with the issues because of the time constraints that are there. I will try to speak a little bit fast. I'm assuming you are being recorded.
Yes. How much?
Yes, I should be done between 30 to 40 maximum. I should be done. My lords, and I will go straight to, I'll mention the specific submissions that I'm responding to. If I don't mention any persons, it is only because I have had to edit the response to fit the timelines that have been accorded to me. Now, first of all, I want to thank this friend of mine, Dr. Mudhomi, for mentoring this young lawyer that we had him making very good submissions. I told him he reminds me of Gibson. He mentored very many people, including myself. And I challenged my assistant, Sylvia Musongo, that if ever Professor Kindiki, who is my friend, also is impeached, he should come like Mutavia to speak to you. Be that as it may, let me come to the business of the day. And I want to clarify, Mr. Mukele had suggested that the specific orders of standing orders of the National Assembly and the Senate have not been challenged. I want just to reiterate that we did so in prayers number 12 and 13 of the re-amended petition. And the next general issue, this is a cross-cutting issue that has arisen, is the questions of may and shall in our Constitution. I will not bother the court with the grammar, which appears differently in very many decisions from the High Court to the Supreme Court. Because we are dealing with constitutional adjudication, the Constitution has already said how the Constitution shall be interpreted, and that includes the word may and shall. In Articles 20, we start with Article 4, I believe. They say Kenya is a constitutional democracy. So in interpreting the meaning of any law, that's the value that you start, constitutional democracy. Values of our Kenya are stated in Article 10. And then we have Article 24, where they say interpreting any law or statute, any intervention by Parliament, they must take into account the fact that this is a free society that believes in democracy and certain value systems. That is in Article 24 of the Constitutions. And then there is Article 259(1) of the Constitution that also says how you interpret the Constitution. So that bearing in mind those provisions, it is our submission that the context in which the word may and shall in Article 145 must be interpreted by the Constitution is by this court examining what is it that it seeks, what is the issue of substantive justice, substantive law that seeks to be secured. And my lords, I submit that the Constitution itself, when you read it, makes it clear that when the motion and the report is received from the National Assembly, Senate shall investigate the matter. Shall investigate the matter. The questions is about investigations. In our earlier submissions, we said why under our system of justice and the adversary justice system, justice must be based on truth, and investigation is how you arrive at that truth. Therefore, if that be the case, then 145 must be read in a manner that upholds that an investigation must be conducted, because that is the principle and that is the value. The issues of natural justice, they are set out in our constitutions, must be incorporated in interpreting that law. So that, my lord, there would be some danger, obviously, that if the usage of the word may, as suggested by the respondents, was to be used to say that you can actually impeach an elected deputy president without investigation, as the Constitution seems to say. Such a reading is absurd. But apart from the absurdity of it, is that it is unconstitutional on the basis of the provisions of the constitutions that we have read. But now, the only other question is a practical question, which is purely a question of common sense. My lords, why didn't the Constitution use the word shall? For the simple reason that historically, because we have imported this impeachment issue, it is not every time that when the National Assembly has impeached a president, like they do it in America, that the president would actually agree to have the trial. So what that means is that you couldn't use shall because if, for example, you are dealing with an American situation, Nixon did not go for trial. Nixon resigned. So that it becomes now an optional issue that at the time when the matter is at Senate, it would have to be dealt with in a prudent manner. What is the prevailing situation? Just like now when you are dealing with the prevailing situation, the lawyer for the first respondent are saying, though the Constitution can reinstate the first petitioner to office, they are nonetheless saying, we may not go take that office. So that, my lord, because of the possibilities of all those intervening, is the reason why you use the word may. Many statutes that I know, I've done a lot of work on these university statutes. There are very many cases, starting with Subachachi. I believe I even defended Hassan Omar when they were trying to get him out of Moi University. My lord, many universities would use the word may. But the courts have over the years said the issue of whether or not you are going to hear a student or any other aggrieved person is not optional, merely because you have used the word may. May cannot take away the fact that in Kenya, natural justice is mandatory. So that what are we saying? Unless this court can say natural justice does not apply to the impeachment of the deputy president, number one, or number two, is also prepared to say investigations were not necessary, then it is not possible to read the constitutions to say that the usage of the word may meant that it is not mandatory. If we apply our value system and the principles of our constitutions, investigations are mandatory. You cannot pass a verdict minus that investigation. Apart from the issue of the doctrine of separation of powers that we talked about it, that parliaments, but I'll come to that question. Ogenda made some good submissions. Is one of the issues we are picking up. No, just relax. My lord, I start with Professor Gedu. I believe he's the one who spoke first, senior counsel. Professor Gedu Muigai said that contrary to what we had submitted, that the Constitution makes provision for the procedure of impeachment of the Deputy President. And I wish to reiterate that it does not. Article 105 of the Constitution says the issue of impeachment of the President. Article 150 requires that you modify the procedure in 145 in order that it can apply to the Deputy President. What does this require in actual terms? I believe I asked Sylvia, what does, because Professor Muigai kept on talking about mutatis mutandis. So what does this mutatis mutandis means in plain English? In plain English it means the original exists, which is 145. Then you need to get, what is it, the generic? That's what they say. You need to get a generic. The generic in the medical world must actually exist. The generic and the original are basically the same medicine except certain ingredients. So, so there must be in existence a document.
That's not correct scientifically, but it doesn't matter.
Okay, I defer to the science. But my understanding of generic, I have a good pharmacist, is that a generic is based largely on whatever was the original drug that is supposed now is generated. Now, be that as it may, in the simpler language then, what it would mean in my understanding is that if you say you have procedure A, 145 for the president, you must be able, when you are impeaching the deputy president, on account of Article 150, to say, in obedience to the Constitution, the National Assembly and the Senate modified it this way. Because the Constitution does not say it will be done through a legislation, it means it can only be done by standing orders. Because those are the two instruments, legal instruments that can be used by Parliament to do anything ordered by the constitutions, legislations or standing orders. My lord, there are no standing orders that have been waived that demonstrate that a procedure was made pursuant to Article 152 of the Constitution. If that be the case, then there is non-compliance with the Constitution, what it says expressly. We needed something to be waived. But it is obvious that they could not be able to undertake this impeachment without somehow creating some procedure. And they actually did that. And it was annexed to the affidavits of the Senate, or the National Assembly. Annexed, I believe, number 2, what did they call it? Part 2 of an annexed bundle. Bundle number 2. It's a big bundle. I couldn't carry it here. Page 1296, and it was 1277. 1277. What did the Parliament and the Senate do? They came somewhat with a program, like those things we have for weddings, saying Gachagua will get 2 hours, National Assembly will be able to get this. And you look at it, my lords, and you ask yourself, this cannot possibly be what modification could have meant when the Constitution says. We don't know who made that program. That they say this program is the one we are going to use to impeach the Deputy President. So that, my Lord, in evidential terms, there is not before you a modification that has been availed by the National Assembly or the Senate. And this explains the reason why, in America, Chief Justice Rehnquist, he has the trial of Bill Clinton for an entire month. But here, because you've come up with some kind of a burial program that ordinarily takes a day, that's how you want to impeach or conduct the trial of a deputy president. My Lord, this would subject us to be a mockery amongst nations that are proud to be constitutional democracies. So I agree with my learned friend, Professor Ogada. There are certain things, and the other gentleman who spoke, there are certain things that are simply not permissible in a constitutional democracy. And one of the most fundamental one is this one. My Lord, the next issue is the issue of timelines.
While you are still there,
Yes, my Lord.
how would you, for example, if the impeachment proceedings
Yes.
be modified,
Yes,
or in less direction,
yes,
and because if you fail to modify, that is also the alternative, that we don't want any moderation. Is that also correct? That there may be no need for moderation.
there is no, when you look at the previous submissions, I didn't want to touch that because I would raise 1,000 objections. But when you look at our submissions, we actually explained, my Lord, because all those things, I believe Mr. Martin Kamaro dealt with it. You can charge the deputy president for all these statutory offenses. Yes, if you don't modify.
Yeah, if you don't modify, is it also an option?
It's not an option.
It's not an option.
Yes. The reason why it's not an option, I'm saying, we explained that the deputy president is not a commander-in-chief. The deputy president does not enjoy any immunity. We explained all those reasons. So you modify so that whereas you can say if the president engages in incitement, and I think he does all the time, you need to impeach him. But if the deputy president engages in incitement or hatred, there is a national cohesion and a penal code that you can resort to. So the modification allows you to be able to factor into the fact that ordinary criminal offenses, and I believe we said a lot on that, cannot be the basis for the impeachment of a deputy president. But serious theft and corruption can be used against a sitting president for the simple reason that in the meantime, he cannot be taken to court one. And since that might threaten the state, that is why impeachment law is there. So that is a logic and the constitutional theory behind it. So it is a must that you must modify. Because this is not the same office. They do not enjoy the same status. When I'll be talking about the constitutional crisis, which is an important thing according to the first petitioner, you will get that point. Yes, my Lord. So to go now to the issue of timelines. My Lord, these timelines are important.
That's a novel point, though, to which we did not address ourselves.
We addressed. That was for our benefit. It was not for your benefit.
Yes, but the constitutional threshold, the differential that is submitting then falls squarely onto Article 27, that is asking for differential treatment for a DP who is elected on the same ticket as the president.
My Lord, I believe in Article 50 of the Constitution. If after I'm done with my submissions, the respondents believe there is anything extra they might say, I will not object. So let us have a flow of my submissions. I would never object. And I didn't object when they were talking.
No,
Yes, my lord.
It can't be like that after you finish the term.
Okay.
You can't come down.
I understand.
Just give them a latitude to comment. They can't come down.
Okay, but my lord, he talks about differential. The differential treatment, the actual modification seeks to achieve differential treatment. That is a direct answer. That one of the person is a president. He appoints everybody, including the people that he appointed that are causing the impeachment of the first petitioner. He appoints cabinet secretaries that have appointed the other people that the deputy president was being accused of. So that's a differential treatment. And therefore, they are not treated as the same. It is a reason for the modification.
So this modification actually is a command?
It's a command, my lord.
According to you?
It is, not according to my interpretation of the Constitution. Yes, our submission. It's a command. Yes, and we have explained the basis of it. The legal basis of it. It is explained in detail. Both in our submissions, actual pleadings, and in our main submissions that we submitted. Yes, my lord. Now, to proceed on that other issue, the issue of timelines is a cross-cutting issue, so I don't need to mention any specific person. But the issue of timelines, and I like to follow 258, why does the constitutions of Kenya, and even in articles of impeachment you will see, sometimes how do we deal, the Supreme Court deals with the elections of the president? They give timelines. Elections petitions, they give timelines. Impeachment, in some instances, they have given timelines. Some instances, they have not. What is the reason for it? Part of the reasons are historical. I'll not go into that. Part of the reasons are technical, and in order to achieve certain other values of the Constitution. So that, my lord, when you look, for example, at how Parliament is going to do its job, Parliament was given latitude through standing orders to ensure, and there is a provision where they say hearing is part of the conduct of Parliament, natural justice, to ensure that you come with your own timelines in order that, in accordance with the Constitution, you can impeach. In the Senate, which is where now the elaborate position is given, the Senate, they gave the 10 days for the committee to carry out the investigations. But, my lord, you will notice that the trial, after the Senate receives the committee of the Senate, of the Senate's committee, there is no timelines that is given. Why is that the case? It is the case, my lord, because you cannot be able to prescribe how a hearing will take place. People get sick, like it was in this particular instance. You cannot be able to tell all that. If it is you as the Chief Justice is supposed to preside, the Chief Justice may not be able to be available, and he might even himself become sick. Even here, for good reasons, we have failed to proceed in the matters in the past. So that, my lord, the whole argument why there is actually no timelines is because you are sitting as a court, albeit a political court. And a court has a duty, pursuant to the adversary system, to ensure the people you want to impeach, you have actually given them the latitude that is required and to decide how they are going to defend themselves. But you cannot have a situations whereby, with like a one piece of paper that looks like a funeral program, you are telling the deputy president that defend yourself in 2 hours, you are telling Parliament, adduce your evidence in this. My lord, that is not the way it's supposed to be. So that, my lord, the point I am making is that in this particular instance, when Senate decides to impose timelines through that program, which is not in accordance with the Constitution that has prescribed timelines, that is outside the Constitution. And that is why the first petitioner is entitled, and his supporters that I represent, to say fair trial was not possible. Fair trial for 11 charges, before some of them were dropped, is not possible in 2 hours. Even chicken thieves Nobody has ever done the trial of a chicken thief in 2 hours. So that's a major consideration. And that's why I'm saying that the question why timelines are there or not there. Because in this case, they were not there. My Lord, we go to the issue of the appointment of the deputy. President has 10 days. He decides he has 2 hours. In fact, the process starts before the impeachment vote has taken place. Why do you have the 10 days? You have the 10 days because in a democracy, you give people that have floated these names. You give people an opportunity to be able to say, is this a good person? Is he effective? All these kind of things. You have 10 days. When you reduce it into hours, it means that the impeachment and the replacement is one transaction. The timelines provided by the Constitution says if there are actually the president has 10 days to carry out transaction 1. Then after that 10 days, you have 60 days to process the issue of the person who will assume this important office. So that, my Lord, you now see what we are dealing with. This parliament, 13th parliament, which I said is a scandal, like the 6th parliament of the 1980s. This parliament, where there are timelines prescribed by the Constitution, they disregard them and do their own things to the prejudice of the Kenyan people. Where there are no timelines, they impose timelines. So that, my Lord, when there is a complaint that within the understanding of a constitutional democracy, fair trial could not be possible, it is because there are good reasons that you can read them by a correct reading of our Constitution. I don't want to say anything much about timelines. My Lord, and therefore, there is a general issue also of the constitutional, of judicial power, the nature of judicial power. There was this argument that it is made in almost all political cases that I am aware of, that the judiciary should be careful, not because it is not elected by anybody, and it should let those people who have been elected to do their job, it is within their discretions, all these kind of things. My Lord, I don't want to say much, but I just want to say 2 things. Article 2, is it true yet? Not true. The article that talks about, that refers, is it? Yes, it's actually Article 2, which refers to Article 10, it's 2. My Lords, Article 2 of the Constitution says how public or state power is to be exercised in Kenya. It talks about, go to Article 10 of the Constitution. That is number 1. So that it is legitimate, and it says everybody is under the Constitution, apart from those national values. So that it is mandatory that everybody must act in accordance with the Constitution. Then number 2, the Constitution says that the courts are the guardians of the Constitution. What the law means and whether any act is in compliance with the Constitution, it is a decision of the judiciary. And last time I had said, not the entire judiciary, but specifically the High Court under Article 165, to decide whether that issue, whether anything done in accordance with the Constitution is indeed the case. It is in that sense that the High Court is the guardian of the constitutions. Because as I've said, everybody else confirms whether High Court did its job as the guardian of the Constitution. So that, my Lord, in making whatever decisions we will be making, the only way the Constitution of Kenya would be our supreme law and protect everybody, however mighty or law, it is by ensuring that the supremacy is upheld and the Constitution remains supreme law. So that this argument of you are not elected, you are not done, everybody else in job works under the Constitution, but the same Constitution says it has appointed the human hand, namely the judiciary, that confirms whether everybody else has acted in accordance with the Constitution. They can take that away in a referendum, where they can also go and say, like they said in 1982, to say Kenya is a single-party state. until, so long as there is a provision of the Constitution, Article 4, saying Kenya is a constitutional democracy, they are bound. Judiciary has the final word on this issue. My Lord, I go to the next issue. Then the next issue is, I believe I've dealt with the role of the Senate. It was a cross-cutting issue. And the important thing that I think I just needed to say about that would be three things that are cross-cutting. Number one, the role of the Senate, it first of all comes from Article 96 of the Constitution. And it is to check, when they carry out impeachment trial, it is to check abuse of executive power. That is actually the main thing, abuse of executive power or any other power that may be arise. So that, my Lord, in checking now that power of the Senate, necessarily the Senate must take into consideration whether the charges that are before it manifest abuse of executive power, because that's the main responsibility. So that, my Lord, when you have an official, because the deputy president, under our constitutions, may be a very important person, except to one thing. The deputy president does not exercise any executive power granted directly to him by the Constitution or any statute. It is important to bear that in mind, because if you don't get that in mind, you might lose a lot. My Lord, the second issue is that I have talked about the mandate of parliaments, where we are saying the Senate was not told that you have discretions to impose your own timelines. And of course, we are talking about the issue of the Senate. And I believe my learned colleague, Ojienda, Honorable Ojienda, this is where we come in, Senior Counsel. My Lord, I agree with what Professor Ojienda said, that when the Senate is performing its function under Article 145, the Senate is really a jury. It's a jury system. You are the function, even with this calendar that they gave, this little program they gave. It's actually said National Assembly. Yes, whatever it is. There is like a program. Everybody can see it. It's a one-page program. My Lord, that one actually said the National Assembly would prosecute their case, and the defense would have their bit. So that for purposes of a regular criminal trial, we know that it was supposed to be there is some prosecutor, there is going to be some defense. And the Senate were to vote. Ojienda, professor, said, we were, what did you say, 67? We were 67 judges. We were 67 jurors. That's actually the case, because that is the way it is envisaged to be. But now, the moment that concession is made, that you listen to argument, the way the judges are doing, you will have your issue in your judgment. You will deliver the verdict. So it cannot be the duty of a judge like it is, like to say, to advance any position. You hear the positions that are being presented, then you make a verdict. It is the same case that was supposed to happen at the Senate. And as Professor Ojienda said, they are jurors. So that, my Lord, I am saying that in order to point out a contradiction. When now in the other submissions they are saying that they could discharge the role that the Constitution says belongs to the special committee investigation, and to decide whether any charges have been, the word they use is confirmed? Substantiated. The jurors cannot play such a role. They pass the verdict. And that is what points out as that contradiction. That you cannot on one hand say we were passing the verdict, we were jurors, but on the other hand we were the investigators. The DCs, Gibson Kamau Kuria told me to come and say that, the DCs of colonial Kenya used to exercise powers of prosecution, investigation, and all this. But that's why we made the independent constitution and now the 2010 constitution. In all those constitutions, my lords, and we have the judgment of Judge Mrima in the Kinoti case, you cannot have a fusion of those powers and to be exercised by the person passing the verdict. So that it is necessary to understand that there is a good constitutional reason why the argument that they were making is completely defective and can easily spoil the good reputation of the Kenyan judiciary if they were to miss such a basic point. And that is why it is important, I said, that needs to be understood. There is a history behind it. We also do it in colonial Kenya. It cannot be introduced by the Senate of the 13th Parliament, bad as it might be in my view. It cannot introduce colonialism in Kenya. My Lord, we go to the next issue, my learned colleague, Mr. Moshemi. I only raise one issue. He said many things, but there is no time. But one issue that he said is that when Mutuse does not belong, Honorable Mutuse does not belong to UDA. He belongs to that party of Chap. That he said, like, by the time when we were doing this, it was obvious to the entire country that the deputy president had lost the confidence of his own party, UDA. But now that is significant because the case I was told to come at advance here is that this was a political conspiracy, a political witch hunt. So that in a genuine matter where you are acting in good conscience, violations of the constitutions, it cannot be preceded by saying that politically, that was the understanding. This man must be removed. Because the impeachment came to replace a vote of no confidence. Confidence is purely political. You actually don't need to give any reason. You can even say Kalonzo takes a lot of time to comb his hair, and we don't want this, and you get him out of office. Well, that is enough in a parliamentary democracy. But if Kalonzo combs his hair too many times, he cannot be impeached. And I believe that's the law of Kenya to distinguish between the two. Here now you had the lawyer for Honorable Mutuse saying that he had lost the confidence of UDA. It confirms the basis of the case that we are propounding. We go to the next issue, Mr. Kamodho. It's called Adrian Kamodho. I don't know whether he's there today. My Lord, you will remember Adrian Kamodho, when we started these proceedings, he was appearing for both UDA and the six responded, His Excellency, the President of Kenya. At some stage, he exited and said, I will only appear for UDA. The consequence is all those things that we have said about the political conspiracy have not been answered. Going by the decision of the Supreme Court saying, in other cases, if you are the AG should answer for the president. I didn't hear the AG answering for the president when we say this charge, number one, of tribal appointments and regional balance, these are things that were done by the president under the law and the people that he has appointed. That is not controverted. So that contrary to the Senate could proceed to indict and impeach somebody and remove them from office without any evidence. It is our submission that before the High Court of Kenya, where somebody says, it is not me, they must give evidence to contradict that. And so, if certain communities have a bigger number in public appointments than others, who is responsible for that? That is not a question that can be avoided by the High Court. It was avoided at the Senate. But the Senate is political, and you can excuse many of them for very many things under the sun. Now, there is the issue of the South, let me deal with the South African judgment. My Lord, I had given you the court clerks, the submissions that we did. I don't know whether they still keep. I had even given them this. I gave you this and this to make it easy. We produced the judgment in a bound form like this, and we had also given some submissions because we were suspecting that we may not have sufficient time to deal with it. But my Lord, I need just to take 5 minutes. We have supplementary submissions Everybody was served with them. They are dated 12th of May 2026. Where I only want to say 3 things. But before I say those 3 things, let me say this. That when we made our constitution, the South African constitution was in existence. And we borrowed quite a lot from South African constitution. But when, my lords, my lady, the South African constitution, when you read it, the substantive provisions on impeachment, they are more or less like the American constitution. There is no, unlike Article 145, they do not have an equivalent where they set out a procedure on how to go about it. There are a number of cases. We are being told case number 1, 2, and 3 about how that subject has troubled South Africans, how to deal with the issue. The long and short of it is that on account of the intervention of the Constitutional Court of South Africa, the South African Parliament made rules that by and large mimics Article 145 of our Constitution to govern the impeachment of the President. That's a broad issue. Now, in interpreting that particular issue in the decision that is before the court, what the South African court said is that where there was provision that investigation were to be conducted upon a committee, some probe committee, finding that it was the current President Ramaphosa, because he was even being told to resign on account of that decision. They said that the impeachment committee is a mandatory provision. The judgment explains that issue at length, because it is because what the South African committee, when they voted not to have the committee, the South African court was saying Parliament does not have power to shield the President from unnecessary constitutional investigation in order that a vote may be carried out. So that they purported to give themselves a discretion that the South African court said, you do not have such discretion. Your work is on merit. You must decide, and after all procedures have been undertaken, you must decide whether the President committed the offense or not. That in plain English. The issues can be stated in a more difficult way for non-lawyers. But that's the main issue that was there. So for purposes of the highlight that we want to make is that in the same way, if the South African text, courtesy of the South African Constitutional Court, has shepherded the making of rules that mimics our Constitution, it is this rare moment.
My Lord and my Lady, I think we have to object because counsel has a duty of candor. And since we won't have a right to address you further, it cannot tell you things that are not accurate. He's telling you the South African Parliament has made rules that are similar to our Article 145. That's not factual. That's misleading. Number two, even on the judgment he's referring, that judgment is just about one rule out of about 8 to 10 rules. That judgment does not tell us what those other rules are so that the conclusion can be made. They are similar to our Article 145. They are not reproduced anywhere in that judgment. He has not himself reproduced them so that he can lay a basis for telling you that they mimic our Article 145. The undeniable fact is that they are different from our Article 145, as perhaps Jupiter is different from Earth. Thank you, my Lord.
Well, the direct answer to that is this. When, after this South African judgment was delivered, we proactively did these submissions, And what we are highlighting these submissions. I remember the court directing everybody else has a right to do additional submissions on the South African judgment. But even before writing, they actually talked a lot about the understanding. Was it my friend, Mr. Kipkogei? It is Mr. Kipkogei. He said what he understands the judgment to be. So that, my Lord, I say, it is the court to decide whether I'm wrong or I'm right. And these submissions, which is what I'm highlighting, the court can be able...
Mr. Kibe is not responding to my objection. My objection is this. He told you not once, but 3 times, that the rules for impeachment in South Africa are textually similar to our Article 145. It is our case that they are not, and I'm saying since he's replying, he's an officer of this court as an advocate. He cannot make claims that he knows or ought to know are factually inaccurate and then proceed, especially when we won't have an opportunity to respond to it.
I think we have found a way of dealing with those kinds of claims because we have noted that parties only highlight sections of rulings or judgments which support their case. And when you go back to the text, you find that there could be an element of parties trying to mislead the court. So I think every party is entitled to interpret a judicial text the way they want, support the court to determine the weight to give that interpretation.
Thank you, my Lord. And I don't mind to be told I'm wrong on that. I was about to say I should be allowed to do an affidavit to provide the rules, but it is not necessary. So that, my Lord, and now I'm forgetting even a few things. I don't know whether that was the intention. My Lord, the point I was saying about now my understanding, the South African, they imported something from Kenya under those rules. Because their constitution does not talk about this special committee. The special committee actually exists from some rules that exist in South Africa. Now, because of that, and they say those investigations are mandatory to be carried out. And there is no discretion for Parliament. That is the most important issue. So that, my Lord, in the same way, and that is the relevance of this particular decision, that in the same way, that times without numbers, we have decisions of the Kenyan judiciary talking about how their South African constitution have had good provisions, like in public participations, and how they have been interpreted. It's also a good moment for Kenyan to, through the judgment of this court, for the Kenyan High Court also to let our constitution shine and draw out to the entire world of democracies that in Kenya, when the makers of our constitution were doing the job for avoidance of doubt, there was a clear procedure that makes this issue not optional. So that in short, the problems, and you've seen is a problem that has taken like 10 to 15 years in South Africa. The problem on how to impeach the president or the deputy president. In Kenya, it is clearly set out, provided that the constitution is complied with. If the constitution says 10 days by a committee, it's 10 days. So, my Lord, that's a golden moment that I have to remind the High Court that we also need now to say we've got a good constitution, it does this. Point number 2 on that issue is this, that you can imagine, my Lord, a situation whereby in South Africa, after courtesy of their constitutional court, they have made rules mimicking Kenya that establishes this special committee, and they say it is mandatory. How would it look like if the same Kenyan judiciary, we thought on the face of it looks like a good constitutional provision, read that constitution to remove discretion? Because the Kenyan constitution, properly read, does not give Parliament this discretion. In South Africa, Parliament, because they made the rules, they appear to give themselves discretion. So that, my Lord, what I'm saying, because we read the decisions themselves and our submissions, is to ensure that the Constitution is read in the correct manner and in a manner, because this is these kind of judgments that will be read 100 years from now, as long as this constitution exists. This is a kind of decision that must be done correctly and to run the error, and I've pointed out why in reading Article 145. If one were to read it as suggested by the respondents, we would scandalize the High Court, the Kenyan judiciary and its profession. Therefore, my Lord, I'm urging you, because when the South African case was delivered, it was a day after we have said, we had interpreted Article 145 in the manner that was confirmed the following day by the South African Constitutional Court. So I urge you to read that decision and our submissions and enable you to interpret properly 145. The second issue on that decision, before I go to this constitutional crisis, is this: that what is it that was moving the South African, the underlying factor? The South African Constitutional Court, my Lord, was saying that in a democracy, you run the risk of actually subverting democracy itself when a constitution says presidential misconduct, presidential illegalities would be done by the necessary vote of parliament after an investigation has been carried out. So that they say this cannot be permitted. To permit a rule that parliament can discharge a constitutional function in a manner that they wish would be an abrogation of democracy. It is the same reasoning, my lords, that I've been trying to persuade you to hold, that an impeachment carried out contrary to the Constitution subverts everything. The democracy itself, it subverts the issue of the purpose that was supposed to be meant. The final issue is what the first petition tried to tell me, constitutional crisis. I have read a few books. As I said, Gibson Kamau Kuria was my employer. We ended up, he used to have very many books on this constitutional crisis. I've read a lot in that area, but I don't want to go into all that. But what was a constitutional crisis, strictly understood in simple language? Who talked about constitutional crisis? Get serious. My Lord, as I've said, those books are many, and there are many articles written in that issue. It's Mr. Muthomi who said that point, that he doesn't want intervention himself, because he made an important point that made the first petitioner to tell me, Kibe, say something about that. This is what I want to say, my Lord. It was a constitutional crisis. Apart from the reading of these books that were talking, Ben Wabueze's many books has written about that. For example, the issue of coup d'etats, the excessive ones. Those are the ones that generate a constitutional crisis in a country, because the country ends up being governed by people who have taken over and with no mandate of the people. And where you cause civil war, you cause instability, and when that instability is traceable to the failure of the Constitution, then you say you have a circumstances whereby you have a constitutional crisis. Now, our Constitution anticipated the possibility that there might be a disconnect between politics and the Constitution, and how the system of government that you put. It is why in Article 3, they said, I believe it's 3.2, that any attempt to establish government other than in accordance with the Constitution is unlawful. That provisions, my Lord, if it has never been read in any other manner, it was put in order to avoid, the mischief here is this: an attempt to establish government other than in accordance with the constitutions end up generating a constitutional issue, a constitutional crisis, and a political disorder. And the immediate context, again, is simple, because it is this: that we say we establish government to run Kenya for 5 years on the basis of a mandate for 5 years granted in the previous election. That government has the purpose of election is to decide which party and which individuals are going to run government. Those who did not, whose parties did not win, and whatever, the constitution in the current constitution says you will be a minority for purposes of running government. And the mandate to run government is a collective mandate granted in an elections by the people who together, like if it's a presidency, president and deputy, who went to seek for the vote of the people based on this or the other true stories or falsehoods, but they get elected. Now, that having been achieved, it cannot be possible by any single individual or in conspiracy with anybody else midstream to change the composition of government. When you change the composition of government, apart from the fact that you violate Article 3 of the Constitution, you also generate a constitutional crisis. Does it manifest itself? Even in ordinary social media accounts, even in ordinary political speech and newspaper reports. You generate it because, like today, Kenyans keep saying that whatever government says happens in Kenya. And because there is no longer, the divide has been blurred. There is no government, the people to govern government and people to hold it responsible. And who suffers? It is the people. Because the institutional mechanism to ensure government is politically held responsible is not there. We used to have PAC, the Parliamentary Committee of PAC and PIC, that the law specifically says these should be held by people who are not in the parties that are running government. Because of the series of events that have happened in Kenya, courtesy of the BBG, that is no longer the case. The government and the same people running these committees, the same people running the minority, are in government. It is a scenario, my lord, what was the cause of all this? The immediate cause of all this was the impeachment of the first petitioner. So that it is important to say that if you are suffering a political problem in Kenya, where government becomes unaccountable and abuse of executive power is the cause, is the nature of is the order of the day, this is traceable to the fact that government, in accordance with the Constitution, was suspended with the impeachment of the first petitioner. That's the important point that needs to be understood, that you cannot talk about a constitutional crisis like something up in the sky. You must reduce it to the elements, what it means and how it manifests itself in a specific country. We are dealing with Kenya at the moment. I will not go to those other issues. But the two and third point now on this constitutional crisis is this. You are told by my learned colleague, Dr. Muthomi, that there is this issue that how can Parliament be faulted for impeaching a deputy president who was talking about issues to do with shareholding and these kind of things. Now, the direct issue, as we have said, is that when you look at the arguments we've made and we are just reiterating, is that he was not accused, because he does not have those powers, of any abuse of discharge of executive function. That you did this, and because you are responsible that 1 or 2 or 3 Kenyan communities are overrepresented in the governance of the country, that there is something wrong. He was accused, because it is important, he was accused. You only talk about either the Kikuyu sometimes or sometimes Gema, and that polarizes everybody else. Karuti Kanyingas, we use the book and we have cited the actual statistics in the affidavit that clearly demonstrated, my lords, that if one, and a court of law must care about facts, if one cared about facts in the current situations since 2022, of public appointments and all these kind of things, the two communities that are actually overrepresented, significantly above their population quota, are actually the Kalenjin and the Somali. That is what the affidavit says. But more importantly, my lord, it is said in our affidavit, and you have not challenged it. Well, it's for the judge to decide. There is an affidavit that is uncontroverted. But more importantly, my lord, my learned friend, Mr. Kamuaro, I didn't even know about that. But he was saying, he was telling me, you know, Kibe, when I read those statistics, what I actually saw is that the Maasai and the Somali are more or less the same number in terms of population. But there are no Maasais. The Maasais are very few. So those are realities, my lord, that anybody who wants to talk about this difficult subject must actually confront with. In fact, he went on and said, I look at the Mijikenda, they seem to be more than Somali. But there are also very few Mijikenda. So that, my lord, this issue, and I talked about being trivialized. This is an actual problem that exists in Kenya. But it cheapens everything when you say that the first petitioner is responsible for it. Because now that for about 2 years he's out, why has it not been rectified? Just the other day, the Public Service Commission confirmed what we say in our affidavits. These are government documents, nothing to do with us. The final point on that issue that... yes, and they have just one point, one small point. That final point, my lord, that you notice is that for purposes of this constitutional crisis, I talked about the attempts by in 2013 to ensure President William Ruto and Uhuru Kenyatta did not contest the presidency. We talked about that case, what a 5-judge bench of the High Court decided. The bench basically said, you know, impeachment, that is the political balance going on. You are impeached, you cannot have presidential ambitions. Presidential ambitions are not, it is not a man who decides I want to be president. It's a community or a number of political organized people who said, we want you to be our leader. So that, my lord, and that was the basis for which they say Article 38 does not just concern the right of an individual to seek political office. It is also protects the political right of his supporters to be able to ensure that you participate in elections. My lord, constitutional crisis, we had it in Nigeria. I have 1 minute, so I don't want to take it time, where they wanted to stop their deputy president from somehow succeeding, interfere with political succession. Actually, interference with political succession is one of the major reasons when you read many of the books, why they generate political crises. My lord, anybody who lives in Kenya knows that since the impeachment of this unelected deputy president, Kenya cannot be described as a very, very stable place. The politics are in a serious state of confusion every day.
I think that is...
I am finishing.
There's no constitutional crisis. And Kenya is not an unstable country.
He talked about constitutional crisis, not me. Let me finish. You will say that in a political speech if you can permit. My lord, Mr. Muthomi, I'm just responding. Muthomi introduced the issue of political constitutional crisis, not me. I'm just trying to say political crisis results into political instability. But the ultimate political instability that can occur in a country is on account of a politically motivated impeachment, to get yourself in such a scenario that you say the leader of an important political constituency comprising probably 25 to 40% of the Kenyan population is going to be excluded by a defective impeachment from realizing the political aspiration. It is called, in the normal electoral language, disenfranchisement. Disenfranchisement of a political community or a political party like we had to deal with the TNA in 2013. My Lord, I urge you that when you consider all that it takes on the issue of what is and what is not a political crisis, the impeachment, there can be no judgment of this court that would cause a constitutional crisis. If the judgment voids the impeachment that took place, only a simple thing would happen. We go to the status quo ante. At that particular time, I believe it's politically untenable, as it seems to be saying, for the first petitioner to say, I want to remain a deputy president. But what it means in practical terms, because it is important that this is said by a constitutional lawyer, it simply means the problem, the issue that was aborted about the proper appointment, the 10 days period, and the 60 days period would have to be repeated so that legitimately and unlawfully we can get a deputy president under our constitution. That is assuming if the first petitioners, this petition succeed, still commits that he doesn't want the job. This court cannot cause a constitutional crisis by upholding the constitutions of Kenya. My Lord, I thank you for the time that you have given the clients I represent and the many Kenyans of goodwill who have called me with all kinds of suggestions to make these submissions. I thank you very much.
Yes, my Lord. My Lord, I'll try within the circumstances, noting that I represent similar clients like those of Kibe.
Oh, thank you.
My Lord, permit me to begin by saying that again, the court is being, or rather all the submissions that have been made before this court, my Lord, they have the intention, and most especially from the petitioners, to preserve our constitutional democracy. The petitions that have been placed before you, my lords, they are all challenging the process within which the first petitioner was impeached. I associate myself with the submissions made by my colleagues and add that, my lord, that today, or when this court will be rising up to pronounce itself, it may find itself in the same situation again where Fidel Castro was on the 26th of July 1953, when he made his speech that history will absolve me. Small synopsis is that he had just made some attempts to overthrow Batista, and he was acting towards the revolution of the people, and the statement that was made was to encourage the people that the revolution shall not be lost by his trial. We hope that the constitution of this country and the people's power conferred by Article 1 shall be preserved by the judgment of this court. My Lord, permit me to begin by reacting to the submissions by my learned friend, Dr. Thionkolu, where he invites you, my Lord, to look at the alleged election of the current deputy president as a constitutional process, Mr. Kindiki. My Lord, submissions were made, and most importantly again by Mr. Noor for the IBC, that the whole process was in conformity with the Constitution. There is nothing that can be further from the truth, my Lord. Mr. Kindiki's process was fraud, unconstitutional, unlawful, and the same is completely a stranger to our Constitution. You are told that it was not mandatory for us to have the commission in office for the commission to oversee the process of this election. My Lord, Article 149 has two very key overriding terminologies. One is that Mr. William Ruto was to nominate. That is, the president shall nominate a person to fill the vacancy. Number two, the National Assembly shall vote. two very key words: nominate and vote. This cannot be said to be anything that Parliament was being invited to approve. Parliament was being invited to exercise the people's power under Article 1 of the Constitution through the delegated democracy process. Of course, the drafters of this Constitution, my Lord, were alive to the fact that it would not be possible for us to go and replace a deputy president through the universal suffrage. That is why they delegated this function to Parliament. So anything that, any process that is initiated or commenced by Parliament and by the President in the attempt to replace this office, this vacancy, must resemble the process in which that person who was removed came into that particular office. That is to say, Your Lordship, if you are to look at Article 148, it says that each candidate in a presidential election shall nominate a person who is qualified for nomination, for election as a president, as a candidate for the deputy president. Again, the candidate for the president is being granted the mandate to nominate. Then you are told that at Article 148, Clause 3, the Independent Electoral Body Commission shall declare the candidate nominated by the president who is elected as president. So we can see the involvement of the IEBC during the direct exercise of the universal suffrage in the exercise of coming up with the nominee of the deputy president. It cannot be therefore said that when we are replacing that particular person who came into office through the universal suffrage and through the process of nomination, that he ought not to meet the qualifications under Article 137 of the Constitution. And who is mandated to make sure that the provisions of Article 137, the qualification, the disqualification, are met if it is not the IBC? There is no process, there is no provision in this Constitution that mandates the Secretariat to execute the functions of the Commission. The functions of the commissions are strictly confined to be executed by the Commission. The argument, therefore, that when Mr. William Ruto wrote to the IBC, he was only seeking for information, we must then ask ourselves, what was the purpose of that information if the purpose was not meant to replace an office, to replace a vacancy? He was not acting under Article 35 of the Constitution, where you are simply saying, I want this information to confirm whether Mr. Kindiki was a registered voter. He was asking for that information for purposes of replacement. And therefore, my lords, this replacement must meet the test under Article 137 of the Constitution. The functions or the qualifications under Article 137 can only be met by a fully and well duly constituted commission. To the extent, therefore, that this process was initiated in the absence of the commission, and when the commission was not duly constituted, this process was a constitutional fraud. There was no one to decide whether or not Mr. Kindiki had met the qualifications designed under Article 137 of the Constitution. And if you want to know that the Commission must be involved in this process, look at its functions, the function the Commission is playing under Article 148. Your Lordship, I go to the next point. My Lord, you need to visit and look at the IBC Act, and most importantly, I'll just mention them. You look at Section 5 of the IBC Act, which defines the Commission. Look at Section 4, again, of the IBC Act, which defines the functions of that commission. Again, Section 10, subsection 6 of the IBC Act, which creates the Secretariat. And it provides that the Secretariat shall perform its duties and shall be responsible and answerable to the Commission. So even this particular time when they are deciding whether or not Mr. Kindiki is qualified, the Secretariat is answerable to the Commission, and the Secretariat is responsible, is answerable to the Commission, and the Commission is responsible. Number 2, Your Lordship, Section 10, subsection 7, paragraph E, Roman 1, again provides that the Secretariat shall execute their functions or shall execute the decision of the Commission. The Secretariat is ideally a conveyor belt of the decision of the Commission. So where was the Commission at this particular time, and whose decision when the Marjan in the conspiracy wrote to Parliament to confirm the qualification of Mr. Kindiki under Article 137? Where was the Commission? Where was the Commission again at night? Mr. Marjan, he cannot replace the Commission. If the people of Kenya, by Parliament, wanted Marjan to execute these functions, they would have expressly said so. My Lord, if you are therefore to confirm that process as a process that conforms to the Constitution and the statute, we shall get to where my learned friend Senior Kibe was submitting, the constitutional crisis. You shall have affirmed a person to hold office fraudulently. That person, to the extent that he was nominated and purportedly voted by Parliament in contravention of the Constitution, Your Lordship, it therefore invites you to look at the import of Article 3. Nobody shall be allowed to form government as, may I read it for purposes of clarity? Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. So even where we are, my lords, to the extent that our submissions confirms that Mr. Kindiki was unlawfully put in office, we are already in that particular constitutional crisis. A government has been formed unlawfully. And the only person who can rescue us from this particular process is this court. My Lord, permit me to state that constitutional offices, and most importantly the office of the President, represents the people of Kenya. And therefore, Your Lordship, if the people of Kenya are to be represented in that particular process when Parliament was voting, Your Lordship, that process of the voting did not derogate the peoples of Kenya's their ability conferred, 1, under Article 1, number 2, Article 10, number 3, Article 118. Submissions were made that public participation was not necessary when replacing this office. Then what were the 60 days for? Why did we Kenyans decide that we have 60 days within which to fill this vacancy? The purpose of these 60 days, Your Lordship, is to make sure that the people of Kenya are fully involved. The vacancy that was created, unlawfully created, did not belong to the President. It did not belong to Parliament. It concerns the people of Kenya. To the extent, therefore, Your Lordship, that public participation was not initiated in this process, and noting that Article 118, Clause 2, provides that when Parliament initiates any other business, they shall call for public participation, Your Lordship, then again, there was serious non-compliance with the Constitution, and a government has been constituted in non-compliance with the Constitution, and hence the constitutional crisis. Your Lordship, I know that the Black Law Dictionary will bail me out on the definition of the term vote. The term vote is not the same as approval. Where the Constitution wanted us to, the Parliament to approve, it expressly said so. This time the Constitution spoke about voting. This voting, Your Lordship, has a meaning that is the only way the people of Kenya can be involved in the replacement of the vacancy that has occurred. And therefore this vote is similar to the vote that took place on the 9th of August 2022 when His Excellency Rigathi Gachagua was elected. There cannot be any other way that a replacement can be done at night, approvals can be done at night, and then the people of Kenya are told that Parliament has voted on your behalf. That's a fraud. Your Lordship, permit me to state that on the issue of the impeachment, my learned senior, the senator for Kisumu, Professor Ojienda, submitted on the gazettement of the impeachment. That gazette, Your Lordship, is a gazette dated 9th of October. If you look at the wording of that particular gazette, it says, pursuant to Article 145, Clause 3, Paragraph A. That is to say, of the Constitution and Standing Order number 78, Sub-Order 1. That is to say that the Deputy President's impeachment was commenced pursuant to Article 145, Clause 3, Paragraph A of the Constitution. I dare submit, Your Lordship, that there is, though the office of the Deputy President and the Presidents are derivative, they are distinct in their functions, and that, Your Lordship, that distinction is what invited the people of Kenya to enact Article 150 of the Constitution, so that there can be clear distinction in the manner in which these offices are managed. Your Lordship, the removal of a deputy president is provided for under Article 150 and not Article 145. So this Gazette notice commenced the process of removal of a deputy president as though they were impeaching a president. That is a fundamental constitutional error. It's an error because, Your Lordship, the people of Kenya were not daft that they deemed it fit to enact Article 150. And of course, Your Lordship, the reason why this gazettement or this impeachment was commenced under Article 145 is because they wanted to run away from the import of Article 150, Clause 2, which required Parliament and the Senate to modify this process. This modification, Your Lordship, has been submitted before. I actually submitted at length on it. But just suffice to say that this was not a discretional question. Neither the Parliament nor the Senate could avoid the modification requirement. It was mandatory. And that is why, Your Lordship, the Constitution deliberately uses the word shall. With the necessary, it says, the provision of Article 144 and Article 145 relating to the removal of the Deputy President shall apply, comma, with the necessary modifications to the removal of the Deputy President. This modification, this application of Article 144 and Article 145 had to suffer modification. The person who was to modify was Parliament. Parliament as defined under Article 93 of the Constitution. They could not avoid and or evade that duty. To the extent, therefore, that the commencement of the impeachment process was initiated by the Senate pursuant to the wrong article of the Constitution, Your Lordship, then this cannot be said that's an impeachment that can stand. They were so much in a haste that anything that was supposed to go wrong went wrong. Who should benefit with these transgressions? Should the Senate, should the person who was in pursuit of His Excellency Rigathi Gachagua benefit? Should it be Mr. Kindiki? It is the people of Kenya who should benefit from the provisions of this Constitution by upholding it. Your Lordship, you are told that His Excellency Rigathi Gachagua had filed affidavits and responses. And therefore, there was no necessity for him to appear and defend himself. Suffice to note, Your Lordship, once more, that His Excellency Rigathi Gachagua was the only witness that the defense was to mount in his for his case. Your Lordship, this was not a trial by way of affidavits. It was a viva voce process. And this viva voce, Your Lordship, again you'll find it under Standing Order 78. When you go to Standing Order 78, you are 78.6, it speaks about the President. It says, where the President chooses to appear before the Senate. Let me go to B. It's just about appearance. So it says, how the President proposes to appear before the Senate, whether in person, by advocate, or in person and by advocates. His Excellency Rigathi Gachagua chose to appear in person and by advocates. He was to appear in person, Your Lordship, because it was necessary for him to conform with the provisions of Order 78:11. That he was to appear and go through the process and the entire motion of the hearing. If you look at against the same order, number 21, it says, after the evidence on the part of the National Assembly has been presented, the evidence on the part of the President shall similarly be presented. I am reading President because, Your Lordship, there was no modification of these standing orders. That is why I am reading President as it is, and deliberately refusing to replace the term President with the Deputy President, because there was no modification. So these standing orders presuppose a situation whereby the person appearing is granted an opportunity to urge his case. That is why, Your Lordship, Order 22 says, a witness presented shall be led in evidence, cross-examined, and where necessary, and only for purposes of clarification of issues that may have arisen from cross-examination, be re-examined. It tells you, Your Lordship, this was to be a full trial. That is therefore, Your Lordship, to say that all the evidence that had been filed by the first petitioner were not to be adopted as evidence or as his full response to the trial. It was necessary for him to be granted an opportunity to be heard. And even, Your Lordship, when the Senate realized of this, they never modified this to say, okay, we can exempt his appearance. You will not find that anywhere in the Hansons. Against the extent, therefore, Your Lordship, that this was not followed. Senate itself violated its own rules. If this process was premised on fraud, how can it stand? Your Lordship, permit me to state that affidavits and the responses that had been filed could not have been taken to amount as a full response for His Excellency Rigathi Gachagua. There was need for the Senate to hear him. Why do I say so, Your Lordship? Because before the Senate decides to impeach or not, there is a duty to find out whether the charges have been substantiated. Substantiating of charges, my lordship, my lady, I understand it to mean that all parties have brought their evidence, the Senate had the opportunity to evaluate that evidence, and then they have, on balance of probability, they'll know which side the scale tilts to. If the Deputy President was never granted that opportunity, can those charges be said to have been substantiated? Substantiating of these charges meant that one, Rigathi Gachagua, was to lose his seat. But remember, Your Lordship, the process of losing this seat must be a constitutional process. If, Your Lordship, there was no substantiation of these charges, how did the Senate arrive at voting, even for those charges that they upheld? One-sided process. Can it stand in law? We'll be making a mockery of our constitution if you were to say that the impeachment ought to stand. We'll be a laughing stock of this continent and those other countries that are striving to achieve the steps that we have democratically achieved. That is why it is important, Your Lordship, to follow what my learned friend Mr. Kibe has indicated, that you have a monumental opportunity to speak even better than the South Africans. Because the South Africans' case did not get where we are. I would love to hear that the people in Uganda, people in Canada, people in Australia are quoting a judgment that was presided over by none other but Justice Evans, by Justice Murima and Justice Mugabe.
There's no evidence on this panel.
Your Lordship.
There's no evidence on this panel.
Sorry, Eric, sorry. I beg your pardon. Justice Eric. Thank you, Your Lordship. So, my Lord Justice Eric, I would love to see your judgment be quoted all over this world. What a good day for you. What a good day for the country. What even a good day, perhaps, for your garage children. What a good day, my lady. What a good day. My Lord, permit me, as I sum up, to refer you to just one more issue about Mr. Mukele's submission. Mr. Mukele's submissions was that the whole process, despite the pronouncement by the Wambora's case, that we are not engaged in a quasi-judicial process. He even tried to say that when we submitted that Senate was sitting as a tribunal, that Senate was not sitting as a tribunal. Your Lordship, when my learned friend, Professor Ojenda, was submitting, he kept on referring to the Senate as a court. So, Your Lordship, the question of whether or not the Senate was sitting as a tribunal or a court or not, it was sitting as a quasi-judicial body, and it was mandated to ensure that all processes that concern itself with the fair trial were observed. And perhaps it's important to note that Mr. Mukele and my learned friend, Professor Ojenda, admitted the non-existence of a statute or standing orders guiding the process of impeachment. Coming back, Your Lordship, to my final submission, whether or not this court can look into the works of the Senate, review it, and arrive at a decision, Your Lordship, it's my humble submission, Your Lordship, that your hands are not tied. They are not tied, Your Lordship, because Article 165, Clause 3, Paragraph D, Roman 2, confers you with the power to interrogate whether anything said to be done has been done in accordance to this Constitution. This thing includes the admissibility of evidence. It includes the relevance of this evidence. You are not stopped from confirming whether the Evidence Act was applied. You are not stopped from interrogating whether there was relevance in the materials that were brought before the Senate. The question whether anything said to be done under the authority of the Constitution or any other law is inconsistent. If you find that the threshold of the evidence that was brought was not sufficient to impeach, then you must find it so. Your Lordship, again, Article 165, Clause 6. Again, you are told that you also have the power, the supervisory jurisdiction power. The High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising judicial or quasi-judicial functions. You still have the power to supervise the Senate. The Senate's functions falls under your supervisory jurisdiction pursuant to this provision. When you're interrogating this, Your Lordship, you are not even barred to confirm whether or not what the members of the Senate contributed spoke to the motion. You're not barred from interrogating whether there was nexus between what they submitted in their effort to find that the motion was substantiated or not. Relevance, admissibility. Your Lordship, finally permit me just to draw your attentions to the said South African judgment. I'll refer you to, I'll just quote the paragraphs and the page. Paragraph 38 of the said judgment at page 20. Paragraph 63 at page 30. Again, this is quite interesting. When you want to interrogate where this investigation was supposed to take place. Was it to take place at the plenary? And if the Senate opted for the plenary, did they investigate? What is the nature of this investigation that the Senate was supposed to initiate? Who was to investigate? Again, Your Lordship, look at paragraph 64, at paragraph 31. It says, the failure by the National Assembly to make rules regulating the removal of the president in terms of section 89 of the South African Constitution constitutes a violation of this section and its validity. The failure to make rules under Article 150 of the Constitution, the failure to modify violates that constitutional provision. Again, paragraph 68 of the said decision, it speaks about modification at page 32. Again, paragraph 73 at page 34, it speaks about the need to substantiate the motion. Again, Your Lordship, look at paragraph 115 at page 49. Look at paragraph 116 and 117 at page 50. The question of the status quo, what my learned friend was submitting to, that is to say, if the petition succeeds, we revert back to the status quo ante, and reverting to that particular position, no constitutional crisis will be occasioned, because we will be reverting to a situation that is consistent and known by law. It is them who believes that they are lawfully in office who may want to urge that particular provision, argument of constitutional crisis. There will be no constitutional crisis by saying that Kindiki is unlawfully in office. No constitutional crisis, but they tend to believe so. Your Lordship, paragraph 134 at page 57, that speaks about public participation, Your Lordship. Again, look at paragraph 146, 148, 147, and 148. And finally, Your Lordship, I try to highlight what I find relevant. Look at paragraph 155 of the Constitution of the said judgment. And my Lord, it deals again with the issue of the failure to modify the rules. Your Lordship, I want to urge you to find that there was no impeachment at all, and that whatever happened at the Senate was a mockery of justice, a mock atrocity to the Constitution, a violation, and it is amount to serious contempt on the part of the people of Kenya. Your Lordship, speak as if you'll never speak any other time. Your Lordship, speak for the people to hear. Speak for the people of Kenya. Your Lordship, the fate of this constitution squarely rests on your hands. The fate of our democracy squarely rests on your hands. The fate of the people's power, the sovereignty of the people, and the ability of the people to govern themselves and decide the government that they want to be governed and the mode of governance rests on your hands. The baby is with you, Your Lordship. You may choose to kill it or give life to it. You may choose to pour the water with the baby or take care of this baby. This baby is only 15 years old, Your Lordship. The Constitution is only 15 years. Let it be preserved by your power. Most obliged.
Thank you very much.
Oh, there's somebody else.
Good afternoon, Your Lordships and my lady. Morara Omoke, counsel for the 43rd petitioner. The first thing is that, Your Lordship, you asked a question during the